Welcome Effectors Harmony followers and welcome to this week's edition of Case Law Review. So what are we looking at today? Cell phones in the workplace. But more specifically, can an employer access or ask an employee to hand over his or her phone if the employer suspects that maybe that person took photos of the company or made recordings of the business, maybe sent text messages over WhatsApp? Can an employer actually lay claim to the information on an employee's phone? Normally the concern or the protest of the employee is, but this is my private phone, you can't use my phone to access certain information, or you can't confiscate my phone because it's a private property, it's my property. And often investigations by employers in terms of misconduct committed by the employees are falling through the cracks because they believe that, or there's this question, can we actually access company information by the employee when the employee use their phone for illegal purposes or committing misconduct by use of their phone itself. So this matter was actually addressed. So you may have in your own mind already, you can use it or you can't use it. But let's see what the court say. This matter was actually attended to by the Labour Court in Sangweni versus Krost Office Products. This is a May 2016 case. And it's quite interesting because employees will very quickly advise or inform employers, but I've got a constitutional right, So in this case, Mr. Sangweni was a driver and also a shop steward of the company. And being in the furniture industry, the company does have some tricks of trade, intellectual property, confidential information. You don't easily want that kind of information to fall in the hands of your competitors, especially with furniture. I mean, you can, all of us, when we go to the stores to buy furniture suppliers or brands, they've got their own specific way of how to make their furniture, their own trademarks, so it's quite important that employees maintain confidentiality in that industry. So in this case, Mr. Sangweni was taking photos of the production line, obviously concerning to the employer, and some other employees also saw him and then informed the employer, but listen, Mr. Sangweni is actually taking photos of the production and assembly line. The employer approached Mr. Sangweni and actually instructed him, number one, to delete the photos, number two, to confirm that it's been deleted, and number three, to hand over his phone so the employer can make sure and certain that the content had been deleted. Mr. Sangweni obviously objected, and yes, obviously he alluded to the fact that it's his private phone. He did not confirm or deny that the photos existed and that he took the photos, but he did say apparently that there are private photos of him and his wife on the phone, and therefore he doesn't want to hand it over. But anyway, eventually the employer, therefore, after multiple attempts to instruct him to hand over the phone so they can confirm that the photos have been deleted, and him refusing to do so, they charged him to appear before a disciplinary hearing. And the charges there were two charges. Number one, failure to delete photos of the company from his mobile phone, or alternatively fail to confirm that he had done so. And number two, refusing to make his phone available to verify that the photographs had been removed, which was a lawful instruction. So naturally the employee, after being dismissed, he was found guilty in this disciplinary inquiry and he was dismissed, and thereafter he challenged it at the CCMA. The CCMA Commissioner, however, found that the dismissal was both procedurally and substantively fair. And it was this decision of the Commissioner that the employee took on review at the Labour Court. Now, in terms of his attorneys, what they alluded to or attacked in terms of the review was in terms of Section 14 of the Constitution, which basically states the applicant's content that the arbitrator neglected to consider whether the instruction violated the applicant's right to privacy contained in Section 14 of the Constitution, which basically states privacy. Number one, everyone has a right to privacy. It shall include the right not to have A, their personal homes searched, B, their property searched, in other words, their phones, C, their possessions seized, or the privacy of their communications infringed upon. They also further contain it in terms of Section 25, subsection 1 of the Constitution, which states, among others, that no one may be deprived of property except in terms of a law of general application, and no law may permit arbitrary deprivation of property. So, the employee obviously attacked, but listen, this is my phone, this is my property, and therefore you as an employer have no right to actually confiscate my phone or try to access it or try to deprive me of it. It's my constitutional right. But the Labour Court, they did not fully agree. They actually referenced and depended on Bernstein versus Bester, okay? And this is where it's getting really interesting now, where the court found that privacy is acknowledged in the truly personal, and this is the key word here, in the personal realm. But as a person starts to move into communal relations and activities such as business and social interaction, the scope of personal space shrinks accordingly. I wonder where other places I've heard about this. It's a case about the Constitutional Court or the High Court in terms of cannabis usage, where people can use cannabis in the privacy of their homes. Your workplace is not your private property or your private space. You can use it in your personal space. In the same year, court is confirming that once an employee is moving outside his or her personal realm, it now enters into the sphere of business and society at large. Interesting also, the court further went to say the applicants rightly contended that in the employment context, the competing interest of employees' right to privacy, it has to be weighed against the employer's right to protect its business interests. In this instance, the employee has a right to preserve the confidential nature of personal information on his cell phone. The company, for its part, asserts its right to preserve the confidentiality of information about its business and its operations. Then the court also depended on a High Court case, Protea Technology Limited and another versus Weiner and others, where the High Court held that the applicant was not entitled to intercept private calls made by an employee, but that where the employee was engaged in matters pertaining to the employer's business, the employee lost the right to the privacy of those communication. So here we have it. If an employee uses his phone for his own personal matters, that's fine. But the moment you are interacting in the employer space, his operations, especially if you're using the time of the employer, and now you're starting to use your phone and probably breach your employment contract or in a conflict of interest or misconducting yourself, like using your phone to copy, to record, to take photos of confidential information, intellectual property. Now you are exiting the personal realm and now you're entering into the space of the employer. And now you have the competing interest of the employer for them to protect their business interest. So this is the competing interest of the employee and the employer in terms of your private property. So here we have it. An employee, if you are using your phone to record data of the employer or take photos of the employer's property, confidential information, copies, emailing it to yourself, the employer actually have a right to demand access to your phone to see if there's copies made, to delete it and try to minimize the risk that that incident may pose on the operations and the business at large. So yeah, so that is this week's for case law review. See you next time.